Hello everyone, welcome to the conference Rule of Law Checklist for Montenegro, organized by the Center for Democracy and Human Rights together with the Konrad Adenauer Foundation under the framework of a project addressing the rule of law assessment, situation assessment in Montenegro. Within this project, the Rule of Law Checklist has been prepared as a part of the Rule of Law initiative conducted for Southeast Europe and based on the Venice Commission's checklist. This report will be presented today at the conference, and it gives a comprehensive assessment of several indicators pertaining to Montenegro to ensure better understanding of the rule of law situation in Montenegro and how it affects on the daily life of its citizens. Before I give the floor to the speakers, I will briefly say something about the agenda at the introductory part. Hartmut. I'm welcoming Mr. Hartmut Rank, head of the Rule of Law program for Southeastern Europe at the Konrad Adenauer Foundation, and Mr. Thomas Marcotte, former secretary of the Venice Commission, as well as Mr. Milorad Markovic, one of the authors of the study done for Montenegro. And after that, we'll have a discussion with relevant speakers, relevant guests when the rule of law checklist for Montenegro is concerned. So that's pretty much all I had for the introduction. Mr. Rank, you have the floor.
Thank you, everyone. Good morning, everyone, and welcome to our conference that we have today in a hybrid manner. Let me first also welcome particularly all the speakers of to our conference. So please, dear Judge Radovic, dear Ms. Pavlicic, dear Mr. Muk, dear Ms. Šimović-Svicer, dear Ms. Jaletic, certainly also dear Dr. Marcotte and Mr. Markovic, author of the analysis. Last but not least, dear Ms. Besic, our co-organizer from CEDEM. Thank you all for being here in the discussion. I'm looking forward to the discussion. And let me just mention that I'm head of the Regional Rule of Law Program Southeast Europe of Konrad Adenauer Foundation. Our foundation also has a permanent office in Podgorica, and rule of law related projects such as the publication we will be speaking today about are sometimes dealt with by our regional office in addition to activities by our Montenegro office. As in some of our events, we've had a very good cooperation with CEDEM. I'm happy that this event today finally can take place, although I'm sad, to be honest, not to be with you in Montenegro to be able to discuss. Nevertheless, this is a conference in a hybrid form. We've said some of the speakers are gathered in Podgorica, but I'm glad that we can have the discussion because legal reforms are currently discussed in Montenegro and we want to be part of the discussions. So, as you all know, today's conference is divided in two sections. We will first be talking about the publication that has been prepared, the Rule of Law Checklist for Montenegro, which is printed and will be distributed to you soon. So, Kontolna lista, vladavine, prava za Crnu Goru. I'm very curious to hear the author of the analysis speaking to us in a couple of minutes, but I would like to share with you why we have decided at Konrad Adenauer Foundation to do this project together with CEDEM, why we think this particular instrument, the Rule of Law Checklist that has been prepared a number of years ago by Venice Commission, is so relevant and why we do it in Montenegro. So I'm happy that we will have Thomas Marcotte speaking about it from the Venice Commission's point of view directly after me. Rule of law. We have a regional rule of law program, as I said. Rule of law is a political idea. How good governance should function. In its core, this idea bears the principle of the limitation of arbitrary power. And only when power is limited, accountability, human rights, democracy, and common good have their place in governmental affairs. This limitation is accomplished by law, and all actions of the states are guided and constrained by the law. And to be more precise, the arbitrariness of individuals in power is limited by the reason of law. Modern democracies would not function if there was no framework that lays down basic rules on which a society can build on. To also quote a different source, the World Justice Project, they note where the rule of law is weak, medicines fail to reach health facilities, criminal violence goes unchecked, laws are applied unequally across societies, and foreign investments are held back. Just to reiterate something that all of you know, it is not an academic discussion if we talk about rule of law. It affects all our lives as well. And rule of law is not a mere idea that is self-fulfilling. It is built on several key pillars. Let me name two of them. The first pillar is the general acceptance in a society that the law applies equally to all its members, nevertheless of the amount of power that one individual holds. The second pillar, and perhaps more important, since it directly influences society, is strong and capable institutions that uphold this law. And that's particularly the reason why this rule of law checklist and the analysis that is built on it brings the focus on institutions and their capacities and willingness to act in accordance with the law and to implement the law. It is very difficult. It's extraordinarily difficult to measure rule of law in any country, not only Montenegro. And it is difficult to render a plausible analysis of the state of the rule of law in a country, since many factors here play in at the same time. And it's sometimes difficult to quantify. Nevertheless, we think there are some key indicators which help us to get a better picture. The global effort to build a meaningful analysis of rule of law has been accompanied by the development of numerous indicators to measure this phenomenon. Indicators, by their nature, reduce complex social phenomena to simple measures and can be misleading. Some indicators measure formal institutions, other measures behavior, yet others measure beliefs. Which indicator to an analysis will use, it depends on the theoretical concept of rule of law. While all indicators appear to start from the core formalist ideal that the rule of law entails rule by law, not by man, just to borrow the quote from John Adams in the Massachusetts Constitution, they each add different substantive values, such as absence of crime, human rights, substantive equality, and security of private contracts and property rights as well. These various indicators build very different substantive values into their definition of rule of law. In this analysis, since we have concentrated our rule of law concept on the performance of state institutions as creators of the legal framework, we use only three main indicators that are inspired by Venice Commission's rule of law checklist. And all of them are further concretized by several operational questions. The key indicators for us are compliance with the law, second, independence of judiciary, and third, absence of corruption. All three indicators are intertwined and are the minimum what is required when we want to talk about rule of law in any country. We cannot speak of rule of law if the courts are not independent and are corrupt. Who will defend then individual rights against arbitrary powers of the executive? Having in mind the before said, we were not interested in an analysis that will just use a normative approach, as most of the law in Southeast Europe actually is formally aligned with the highest standards of rule of law. Written laws seem to be perfect. This said, that is always the reason we do not use certain indicators which contain values such as equality of law, non-discrimination, etc., since those values are mostly built in the legal systems of the countries here in Southeast Europe. More substantially important is if the laws that enshrine those values are respected in practice. So we are interested in rule of law in action. To measure and analyze the performance of the institutions of Southeast European countries, this analysis uses empirical qualitative data and quantitative data. We will hear about that from the expert who will present the findings later on. Data for every indicator. These data are then analyzed by combining qualitative and quantitative approach to get a more accurate full picture. And that is also the reason that this analysis gives equal weight to qualitative and quantitative methods. I hope I raise some interest in the findings that will be discussed in the first half of our event today, as I said, but before we will be hearing the findings of this document, which is also available on internet, we will now hear Dr. Thomas Marcotte, the former secretary of the Venice Commission. Thank you all for your attention.
Thank you very much. Ladies and gentlemen, it is a pleasure for me to speak at the opening of this conference, which addresses an issue, the rule of law, which is crucial for the future development of Montenegro as well as of other countries. I would like to thank the Konrad Adenauer Foundation and the Center for Democracy and Human Rights in Montenegro for the invitation and for using the Venice Commission checklist as the basis both for the study and for today's conference. In my opinion, the study you made clearly demonstrates the usefulness of the Venice Commission checklist. The Venice Commission indeed prepared the checklist in order to make it easier to use the concept of the rule of law for practical purposes. The rule of law is mentioned in the preamble to the Statute of the Council of Europe as one of the three principles which form the basis of all genuine democracy. The preamble to the European Convention of Human Rights refers to the rule of law as an element of the common European heritage. Together with democracy and respect for human rights, the rule of law is one of the three core values of the Council of Europe. These core values should not be considered as separate, but they are interlinked and overlap. Without political freedoms, such as freedom of expression, there can be no democracy. And without an independent judiciary to enforce them, fundamental rights guaranteed by the Constitution and by legislation risk being meaningless. Without the rule of law, there can therefore be neither democracy nor respect for human rights. The rule of law is, however, as pointed out already by Hartmut Rank, not an easy concept. Human rights are precisely defined thanks to the European Convention of Human Rights, but there is no treaty defining the rule of law. Many aspects of the rule of law, such as the need for an independent and impartial tribunal, are included in the European Convention of Human Rights. But the Convention does not, and is not meant to, provide a comprehensive picture of the rule of law. The state of the rule of law in a country is far less visible and more difficult to assess than the functioning of democracy. Elections are the core element of democracy, and thanks to a system of international election observation, there is a lot of relevant information allowing to assess whether elections are free and fair. By contrast, there is no general mechanism to observe the state of the rule of law in countries. Moreover, there are different traditions in Europe. The rule of law, as traditionally understood in the English-speaking world, is similar but not identical to the German concept of the Rechtsstaat or the French concept of état de droit or prééminence du droit. The Russian concept of verkhovенstva zákona is quite different and limited to the principle that statutes, laws in the formal sense, have to be respected by everybody. This concept is far too narrow and has often been an obstacle for the full realization of the rule of law in the former Soviet Union. So-called thin concepts of the rule of law existed focusing on the absence of arbitrariness, as well as thick concepts of the rule of law, integrating other aspects, including fundamental rights. There was therefore a need to define the concept of the rule of law more clearly and make it easier to use. This need became particularly obvious after the fall of the Iron Curtain, when the post-socialist countries had particular difficulties to establish the rule of law. These difficulties persisted even in countries that had joined the European Convention of Human Rights and which could be considered as democracies. Politicians became more and more conscious of this problem, and in 2007, the Parliamentary Assembly of the Council of Europe adopted a resolution drawing attention to the need to ensure a correct interpretation of the concept of the rule of law, and it asked the Venice Commission to further reflect on this concept. The Venice Commission probably was indeed the ideal body to do so. Its official name is not Venice Commission, but the European Commission for Democracy Through Law, and the relationship between law and democracy has always been at the core of its activity. In 2011, the Venice Commission adopted a report on the rule of law. Its task was facilitated by the fact that the different European traditions were already converging, and that aspects of the concept, such as the independence of the judiciary, were increasingly defined in international soft law. States also had in general a positive approach to the rule of law, since they are conscious that respect for the rule of law was important for economic modernization. Under the Swedish chairmanship, the Committee of Ministers of the Council of Europe adopted in 2008 its own report on the rule of law. And at the time, states, such as certain states of Central Asia, which were allergic to the notion of the rule of law, to the notion of human rights, were ready to cooperate with the European Union in the field of the rule of law. Ladies and gentlemen, the United Kingdom is justifiably proud of its tradition of the rule of law. During the United Kingdom chairmanship of the Committee of Ministers of the Council of Europe, the United Kingdom co-organized the Rule of Law Conference in London in 2012. This conference encouraged the Venice Commission to develop a rule of law checklist to make the concept of the rule of law less abstract and more operational. The Venice Commission adopted the checklist in 2016. This was not easy for the reasons already mentioned. Also, there are many aspects of the rule of law, and the concept has to be adapted to the situation in each individual country. There are different options on how to implement the rule of law. For example, while in most European countries, the Constitutional Court plays an important role to promote the rule of law, the existence of a Constitutional Court is not a necessary requirement for having the rule of law. There can therefore be no one-size-fits-all list of criteria, but different elements will be important for different countries. It is therefore fully legitimate that your study on Montenegro we are discussing today focuses on some elements of the checklist, such as the independence of the judiciary, the prosecution service, and the fight against corruption, which are considered particularly relevant for your country. Indeed, the fight against corruption is considered as being increasingly crucial in a large number of countries. In a small country, such as Montenegro, where people know each other, the risk that the state acts on the basis of personal connections instead of on the basis of rules is particularly big. The Venice Commission checklist had a very positive echo. It was endorsed by the Committee of Ministers, the Council of Europe, the Parliamentary Assembly, the Congress of Local and Regional Authorities, all the organs of the Council of Europe. This would seem to indicate a large consensus on the concept. This, however, is somewhat in contrast with the fact that the concept of the rule of law has increasingly been contested in recent years, especially in Poland and Hungary. Well, nobody in Europe will seriously argue that democracy is a bad thing or that human rights should not be respected. The rule of law, which was previously accepted as a concept even by fairly authoritarian regimes is increasingly attacked as an ideological construct. It is possibly no coincidence that this criticism comes mainly from member states.
Sorry, can you hear me?
Candidate states to the European Union, such as Montenegro, may have problems fulfilling all the rule of law criteria, but they are conscious that they have no choice.
Mr. Marcotte, can you hear me?
If they wish to become members of the Union. This new criticism of the concept of the rule of law is probably due to the very success of making the concept practically relevant by developing more precise criteria, including through the checklist. If the rule of law does not remain a vague concept, but has very practical consequences, and is to be seriously implemented in practice, it becomes a threat to authoritarian regimes. By their very nature, these regimes wish to control everything, usually included, in order to govern without any constraints. Such constraints are, however, crucial if we wish to live in a free society, and it is therefore essential that we continue our efforts to fully implement the rule of law. Thank you very much for your attention. I look forward to an interesting and stimulating debate.
Thank you, Mr. Marcotte. Thank you, Mr. Rank. And once again, I'd like to thank CAS Foundation for their continuous support to our organization and the activities, the rule of law activities we carry out. And whenever we also carry out the activities bringing closer our country to the rule of law. So greetings to Mr. Milorad Markovic as well. Please tell us something about the main findings of the rule of law checklist for Montenegro. Thank you for the introduction. I would also like to thank SEDEM and CAS for this very good initiative to conduct an analysis, a rule of law checklist analysis according to the Venice Commission's checklist. It seems that the analysis has shed some additional light on the rule of law situation in Montenegro. I would certainly like to greet all the previous speakers who have given a brief overview of the understanding of the rule of law, which is extremely important. It's important to know that the rule of law is a concept which is very difficult to define or cannot be actually put in one definition. As such, it is also a concept that takes different shapes in different countries, which makes it, requiring a specific approach depending on the national context, and the same applies to Montenegro. I would also like to greet the panelists. After my presentation, they will have the floor, so it is my honor to present this report before the panel, because I believe that the panelists will tell us more about the state of play in Montenegro when rule of law is concerned. I would also like to welcome all other participants, our dear colleagues who are with us here on the Zoom platform. I see so many of them, and I know that they are all esteemed experts who have been active in the sphere of rule of law by both monitoring these processes and taking part in the reform processes that are intended to ensure the desired level of the rule of law, level desired by Montenegro, but also required by the Council of Europe and the European Union. When preparing this report, this report was prepared by several colleagues, and I would like to thank my colleagues from SEDEM for their contribution. It's an honor for me to be given the possibility to present this report on behalf of the expert team that has drafted it. So once again, I'm thanking my colleagues, and I'm underlining that this report is the result of our joint action. Especially I'm thanking Ms. Anna Rajcevic, who is the co-author of this report. The report was prepared in September 2020. It reflects the situation that existed at the time in Montenegro. We are all aware that since September 2020, we have experienced some substantial changes in the political life, but these changes too, also affected some of the issues addressed by our report. And because of that, the findings of the report and the data that we presented in the report should be actually considered in that light. I would also like to underline that the changes that have taken place and some key issues pertaining to independence of judiciary primarily and legal amendments to laws on judiciary. Well, actually, these developments have not had any substantial impact on the findings and conclusions of this report. So, of course, my opinion is that the findings and those recommendations and findings of the report are still relevant, and they give an objective picture, an objective overview of the situation, primarily when it comes to laws on prosecution services. Just like our previous speakers already made it clear, this analysis is based on the Venice Commission's checklist. The checklist has been partly adjusted within the Southeastern Europe Rule of Law project implemented by CAS. And the checklist and the parameters and the indicators give sufficient basis for an objective analysis of the situation, rule of law situation in Montenegro. But two things should be kept in mind. We've looked into rule of law through three key indicators. So the findings and recommendations, well, they do not pretend to be final conclusions as to causes of certain shortcomings in the rule of law situation in Montenegro. So in that sense, certainly this analysis is a good and a solid basis for deeper, more thorough analysis. It should be, and it is actually our intention, to have an analysis which will be made available to the academic community, experts, NGOs, and particularly legislative bodies and the government. They can use the analysis to try to identify the key causes of the identified shortcomings. As already said, the checklist that we used has 12 indicators divided in three categories: compliance with law, independence of judiciary, and absence of corruption. They are mostly focused on protection mechanisms, procedural protection mechanisms that show how rule of law principles have been incorporated in the legislation. As I already mentioned, the purpose of this methodology is twofold. One is to assess the rule of law situation in Montenegro in order to identify and analyze the key shortcomings and limitations through selected indicators. But it is also very important that this analysis gives us a solid basis for further formulation of policies addressing these shortcomings. SEDEM wanted to use this analysis to analyze the aspects of consequences of the COVID crisis, to see simply how COVID has affected the rule of law situation in terms of observance of law and harmonization of secondary legislation and decisions of the executive branch of power with the laws. So in that sense, the analysis also gives an additional contribution. Of course, when constitution is the starting point, when it comes to the sources of information, also we looked at constitution, primary legislation, secondary legislation, reports of international bodies like CEPEJ, Council of Europe bodies, and also reports prepared by our colleagues in the NGO sector. We definitely also looked into and used the official documents of institutions, primarily judicial institutions. And here I refer to their annual report. They give quite a good starting point for thorough analysis of the situation. I said that we used three indicators: compliance with law. Within that part, we have specific indicators: supremacy of law, first of all, then conformity of laws with just constitution, and conformity of secondary legislation with primary, then accountability, impunity, enforcement of judicial decisions and government decisions, and also efforts ensure uniform practice. We all know that supremacy of laws means that everyone, both citizens and institutions, have to abide by the laws, by the legislation in force in Montenegro. We always underline that the national legal system also, through Article 9 of the Constitution, means that all laws have the supremacy, but also they have to be aligned with international customary law, international ratified treaties. Of course, Montenegro has also joined and signed numerous international human rights treaties. And we are all aware that Montenegrin legislation is very productive. We are at the integration process, and a whole set of different pieces of legislation of the European Union acquis has been incorporated in our system. So what's extremely important is to see how exactly these activities are carried out, how much consensus we have, how much presence, how much engagement of different stakeholders is ensured for that purpose, because they have a significant role in legislative activities. And it seems, actually, and that's what the conclusions of the analysis say, that the government is considered to be the main legislator. So what's missing here is more involvement of the parliament, meaning in terms of, well, development of laws, drafting of laws, and their impact on the final version of the laws, despite the fact that the Parliament of Montenegro has also introduced higher criteria regarding their personnel. But still, we can conclude that the Parliament does not have many influence on the legislative reform. So, having in mind the role of the Parliament, primarily its democratic capacity, it's very important to ensure that Parliament improve their involvement here. One of the key conclusions of the analysis is that the proposed pieces of legislation sometimes are not properly justified and are not properly discussed. In the previous period, we've had cases where certain regulations were unanimously accepted. So, regarding compliance with law segment, we will all agree that we have a big issue regarding conformity of the law with the constitution, laws of the with the constitution, and conformity of secondary with primary legislation. One of the key, issues in the previous period was the fact that the government decided to publish the list of names of people who were infected with COVID, which was a direct violation of their fundamental human rights. This decision was not in line with the legal framework, our constitution, or the obligations of Montenegro stemming from international treaties. Regarding responsibility of civil servants before law and their impunity, we've dedicated to this topic a substantial portion of our analysis. I will merely touch upon issues related to failure to punish torture, failure to prove, and failure to properly sanction cases of torture committed by civil servants, despite the fact that we also already have some case law of the European Court of Human Rights positively assessing the actions taken by the state in that respect, but still additional efforts are here needed. When it comes to enforcement of judicial decisions and government regulations, also in addition to the reform that's been taking place in the last 7 to 8 years with the introduction of notaries and bailiffs, all these things have resulted in positive effects, meaning that cases before courts, the number of cases has reduced and the efficiency has increased. Also, SAPEJ analysis tells us that the ratio between inflow and outflow of cases is relatively low. After the introduction of the public bailiff system, after 7 or actually 8 years, which is how long this system has been functioning, clearly we can say that we are now thinking about certain legislative changes. Let me give you an example what needs to be changed. That's the bailiff's role in assessing authenticity of documents provided in enforcement proceedings. They don't have that possibility now, and they are required to verify authenticity, but they do not have the means to verify that. Also, I would like to underline the role of ombudsman regarding compliance with law and more successful enforcement of judicial decisions. Also, enforcement of decisions of the European Court of Human Rights. In Montenegro, we do not have these procedures in place, which are activated when we do not have a clear, precise enforcement of this court's decision. All of the decisions of the court in Strasbourg were implemented in Montenegro properly. But this is very important because Montenegro is one of those countries that has an extremely high index of applications per 100,000 inhabitants. So compared to all other Council of Europe member states, this index is 6.86, whereas the average for COE member states is 0.53. So in that context, we should really commend the fact that enforcement of decisions of the European Court of Human Rights is at a quite high level. In this sense, we should also say something about the Supreme Court of Montenegro and the fact that we already have some visible results of previous activities. This court has established 2 new divisions, case law and legal IT division, and the division for EU law and case law of the European Court of Human Rights. And these divisions have taken a set of activities, education activities intended to clarify certain legal positions and also certain dilemmas that Montenegrin courts are facing. However, the conclusion is that Montenegrin courts do not cite the case law of the European Court of Human Rights sufficiently. And I would say that in certain issues, for instance, right to privacy and right to freedom of expression, in that respect, Montenegrin courts have had quite a good case law from the aspect of observing and citing the decisions of the European Court of Human Rights, but that's not the case for other issues. On the other hand, the Constitutional Court fully implements and complies with the case law of the European Court of Human Rights. They, in all their decisions, they quote excerpts from their decisions, but my personal view here is that I believe we rather have a formalistic approach. They always quote their case law, but in other cases it's really questionable. In some cases it's really questionable whether such case law has been properly interpreted and properly translated into situations and cases heard by the Constitutional Court. But it is something to be commended, definitely, the fact that the Constitutional Court has taken such approach. We hope that in time more progress will be achieved in this respect. So in the segment related to harmonization of laws and supremacy of laws, we can say that moderate progress has been made, but insufficient results that have been achieved. So implementation of law, and harmonization of primary and secondary legislation and decisions of the government, well, all these aspects should be further improved. The second indicator implemented through this analysis might be the most interesting and most relevant for the Montenegrin society and judiciary today. We have considered here 4 sub-indicators: the role of competence of the Judicial Council, appointment of judges and prosecutors, funding of judiciary, public perception, independence of judiciary. I will try, and I know actually that we will talk about this in more detail a bit later, but I will just highlight certain conclusions, key conclusions, which build upon the positions of the Venice Commission regarding the role of the Judicial and Prosecutorial Council. And their recommendations are pretty much the same for both councils, and they are related to depoliticization of Judicial Council and the influence on the work of Judicial Council, also in terms of their membership and participation of the President of the Supreme Court and Supreme State Prosecutor, who also have the role of the controlling entities. And also in terms of the possible influence that they may have on membership in these 2 councils. We also touched upon objectivity and the politicization of members who are not judges and prosecutors in the councils. In the current legal framework, there are no sufficient guarantees reassuring us that we will not have political influence on any of the 2 councils. I primarily refer here to the method of selecting esteemed or renowned legal experts as members of these councils. So there's this restriction that they cannot have a political background, or they cannot be politically active in the political life of Montenegro. And also the participation of the executive power, automatic membership of the Ministry of Justice in the Judicial Council, and representative of the Ministry of Justice in the Prosecutorial Council. So I will stop here when this specific topic is concerned. I know we'll talk about this in more detail later. There's this position that the Venice Commission took before we ended up in this situation with the prosecution services laws, and that's that the depoliticization and the undue influence inside prosecution, inside the judiciary, that political influence should be reduced by legal amendments and by further reform of the organizational laws in judiciary. As for the appointment of judges and prosecutors, the 2015 amendments had made a certain progress to a certain degree, but still reserves are there regarding transparency and meritocracy in the appointment process. Also the issue of responsibility, ethical responsibility, disciplinary responsibility, for performance appraisal issue for judges and prosecutors. That's also an issue, another issue raised from the aspect of the rule of law, actually. In other words, how we interpret and implement certain provisions. Just like the introductory speakers say, we can't really give any special criticism on disciplinary provisions or performance appraisal provisions as much as we can be critical actually regarding implementation of the law. Also, the councils have adopted guidelines, prosecutorial council adopted guidelines for interviews with candidate prosecutors. Also, Judicial Council adopted rules on performance appraisal with criteria, sub-criteria, and indicators, and that is a huge step forward. However, there's this shortcoming regarding uniform implementation of all these rule books and guidelines. Also, the issue of financing of judiciary remains open. Certainly, the budgets of judicial institutions, prosecution services, and courts have to be an integral part of the state budget, but criteria should be formulated to ensure financial independence of judiciary. And the Consultative Council of European Judges has given certain recommendations in that respect. From the aspect of public perception of independence of judiciary, that is a very important criterion, because as subjective and imprecise as it may be, it does give a rough picture, a general picture of how much our citizens trust in the judiciary. According to Eurobarometer, only 49% of citizens believe the police. Less than half of them, 48%, said they have trust in judiciary. Judicial reform is efficient, and its indicators are efficient as much as the citizens feel the benefits of it and as much as they are happy with the results. SEDEM has been continuously analyzed and scanned the public perception of trust in judiciary in March 2020. 34% was trust. In December 1 year before, 41, whereas in December 2017 it was 48%. So we can see that a constant drop in trust in the judiciary has been recorded. And in 2020, according to SEDEM survey, 37% of citizens trusted in judiciary, and almost as many citizens had trust in prosecution services. The third indicator, also very important, the introductory speakers said it themselves, and that's absence of corruption. And exactly how the way it's defined, absence of corruption, it's not about whether we have corruption or how much corruption we have. It was defined in a positive way, absence, if we have ensured absence of corruption. And we've looked at it through several sub-indicators: public perception, high-level, low-level corruption, but this share of high-level corruption cases in prosecution, efficiency of high-level corruption cases, prosecution. So public perception, on that, 3/4 of citizens believe corruption is a part of everyday life in Montenegro, which is certainly a matter of concern and a clear indicator about existence or absence of corruption in Montenegro. This perception is related to all segments of the society: healthcare, education, inspection, affairs administration, customs, police, prosecution, judiciary, all segments of the society. It should be underlined that citizens believe that both low-level and high-level corruption are equally dangerous for the society. However, from the aspect of the most frequent identified forms of corruption, well, clearly the public notices low-level corruption much more than high-level corruption. This actually we learned from the from analyzing the cases handled by state prosecutors. We should say that this division of corruption into high and low level is actually a division that has certain practical aspects in organizational sense. And this high-level corruption defined in the law on courts and special state prosecution actually was intended to restrict the scope of authority of the special prosecution service, primarily to reduce the workload of this institution. And I will say right away that this attempt has failed. That's at least what the data show. When it comes to criminal complaints filed in 2019, this percentage, well, these are criminal complaints filed directly with special prosecution service. I don't know what the reason for this is, whether it's a lack of understanding of this division into high and low level corruption. Well, that remains to be seen, but the fact is that only 16% of criminal complaints filed in 2019 were related to low-level corruption. All other corruption cases, 84% of them, involved high-level corruption offenses. And the 16% they relate to complaints filed to basic and higher prosecution, but also it relates to the cases when special prosecution delegated such cases to lower ranking prosecution services. Let me underline right away that the definition in the law on courts and the law on special prosecution is too broad, having in mind the special authority of the special prosecution. Their powers regarding corruption cases should be limited really and truly to the corruption offenses which are actually effectively at the high level and which are quite specific, instead of putting basic and higher prosecution services into a subordinate position. Higher prosecution services, especially because their powers are quite broader in this respect, and they also have the authority to handle corruption cases. We also believe that the results of special prosecution services reflect the fact that they have been overburdened with some of these cases. Let us not forget that special prosecution service focuses on organized crime in their work. So when high-level corruption is concerned, it accounts for 58.7% of cases handled by Special Prosecution Office. This is quite a high percentage regarding efficiency of criminal prosecution. We have to have in mind that corruption offenses are quite specific, very difficult to prove, and that they also involve special investigative methods. Unfortunately, the Constitutional Court made a decision back in 2018 preventing the second set of secret surveillance measures from being used. And the Criminal Procedure Code is yet to be implemented, yet to be amended to exclude such restriction. So the issue of efficiency of special prosecution in corruption cases is still, well, to be analyzed. We still need to see what are the key causes for that, key reasons, because special prosecution had almost 500 reported offenses of corruption. Almost 1,000 cases in total they've had of this nature. They handle, and when it comes to their final results, very few cases have been completed from the moment of criminal complaint all the way to final and enforceable judicial decisions. So in practice, in work of the Special Prosecution Service, the ratio of corruption cases to total number of cases of special prosecution, we see that we have more indictments in organized crime cases than in corruption cases. Also regarding structure of corruption offenses, in 95% of cases we have two criminal offenses: abuse of official position or office and abuse of economic activity. These are quite general offenses. These are not classic corruption offenses such as bribery. We only had one bribery case in 2019. I will just briefly read out what's written here. I guess some of the participants will have questions. And I've presented findings in principle. I will now just read out the recommendations: the need to ensure proper implementation of tripartite division of power, while focusing on parliamentary democracy, in which the highest legislative body should efficiently exercise their powers. Also ensure full respect for the system of balance and checks to prevent that judges are exposed to undue influence, and also to prevent undue political influence of judiciary by amending constitution, involve Ministry of Justice and President of the Supreme Court in Judicial Council. Supreme State Prosecutor should also not be a member of the Prosecutorial Council. Amend the law on Judicial Council and courts and State Prosecution Service to ensure better guarantees of impartiality and objectivity of members of the councils as key independent judicial bodies by prescribing transparent and objective criteria for their selection, and also by making sure that non-judicial members are not those who have political background or are politically active. Change law on prosecution according to the law on Judicial Council and judges to make sure that renowned experts have their term of office extended if the Parliament does not appoint new members. Also to define the methods of selection for those whose office is extended also. Risk assessment should be the basis for legislative changes regarding differentiation of powers in a way that Special Prosecution Services deals only with certain kinds of corruption cases, whereas other prosecution services should expand their scope of authority due to nature of corruption. State authorities should focus on investigation as the key phase for collecting sufficient evidence. Specialization also in the fight against corruption is a prerequisite for positive results, and it requires further capacity building in police and state prosecution service. I truly hope that you will all have the opportunity and the need to read for yourselves the report or what I've just briefly presented today. There are so many detailed pieces of information, facts, and recommendations in the document. I hope this will be beneficial and useful for all those who are involved in the reform processes in Montenegro. I remain open for your questions, and of course in the panel, thank you once again. And I'm sorry if I have taken too much of your time. Mr. Markovic, thank you. If there are any questions, you can ask them now. Judge of the Supreme Court, Mr. Miraš Radović. I'm sorry, I just wanted to apologize that I was late. There's one thing that I'm interested in. I heard when you said that the law on Judicial Council and courts was a good law, but what's missing is proper implementation. I could agree with you on that, when you say that the law needs to be better implemented, and that's definitely true. And we should all agree on that. However, well, and given also that I will be a panelist a bit later, I wanted to ask something just to check something for myself. Do you really think that the law on Judicial Council and Court is really good? Actually, its segment regulating disciplinary responsibility of judges and that's something that I'm very interested in. Do you actually believe it's good? And that's something I wanted to share with other people, and I believe that debate is the only way for us to reach proper solutions to problems and to define proper arrangements. Thank you, Judge Radović. So the conclusion, in principle, is that the law on Judicial Council and judges is of good quality. In principle, and certainly the key issue when our laws are concerned is their implementation. This law is not good enough. Well, is not good enough in a sense. Is not good enough in a sense that it doesn't need certain interventions, but it is good enough in a sense that its implementation, actually in practice, should be improved. It's important to say that the law, and I believe you'll agree with me, that the law cannot be the framework within which all provisions, all criteria, sub-criteria, indicators for both selection of judges and their evaluation, their performance appraisal later. Instead of that, practice, separate guidelines, rule books, sub-criteria should be used to regulate this area in more detail, to say specifically what are the criteria for their selection and for their evaluation, because the law itself cannot simply include all the necessary criteria and all the necessary details. In that sense, I believe that an objective approach to implementing the provisions of the law, but also not just law, but the rule books and guidelines adopted by the Judicial Council will give us the possibility to truly ensure impartial and objective selection and evaluation of judges. Of course, there are certain provisions that should be amended, that should be further reinforced, as I said, also from the aspect of accountability. Accountability in judiciary is definitely, and generally speaking, an area which tells us that judges and prosecutors themselves are inactive when it comes to reporting unethical and unlawful and wrongful conduct simply of their colleagues. The Ethics Committee, for instance, of the Judicial Council has some notable results in that respect, whereas others, such a committee of the Prosecutorial Council or disciplinary commissions, they have not achieved such results. But on the other hand, it's also about the mindset that must be changed. But we can't change it only by laws. When rule of law in Montenegro is concerned, it seems that we always can. There's always room for improvement of the legal framework, and it very often turns out that these deblocking mechanisms regarding appointment of the Supreme State Prosecutor and members of the Judicial Council are not efficient and effective. In principle, they are sufficient to make us believe that we ensure rule of law in such a fragile democracy such as like Montenegro. But clearly, in practice, we see some opposite results. We see that we can't really, that the deblocking mechanisms that we have are not adequate and are not corresponding to the context in Montenegro. So the laws should be further improved, but the key issue when rule of law in Montenegro is concerned is implementation of the laws and the change of mindset. These two processes should take place in parallel. Okay, let's make a 5-minute break and then we'll continue with the panel. Allow me to thank you once again on behalf of the SEDEM organization. Thank you for being with us here today, dear ladies and gentlemen, and dear panelists. Thank you for accepting our invitation to this hybrid type of event where we can, well, some of us can see each other and meet each other in person. We've tried to comply with all the restrictions introduced due to pandemic. So thank you who have actually physically joined us here. You should also know that the panel portion of the event will be on social media. For all those who are with us on the Zoom platform, they'll have interpretation, simultaneous interpretation provided. Also, I'm welcoming all those who are with us on Zoom. And I would like to encourage them to ask questions. They can use the chat box or the raise hand option for that. I would also like to ask our panelists to keep their responses short, to make them last up to 5 minutes. The plan is for us to have 3 rounds, 3 cycles. In each of the cycles, each of the panelists will be asked 1 question. So after these technical remarks, before we start with the discussion, I will briefly go through the key findings of the report in the context of the actions taken by the new government and in the context of the new EU enlargement methodology. As Mr. Marcotte said, this report was prepared in August and September 2020. At the time, we had parliamentary election. the governing structure has changed, the parliament and the government were formed afterwards, so certain changes have taken place in relation to the findings of the report. So the idea is, as it was said several times by the introductory speakers and Mr. Markovic, and we have a consensus on this, that normative and institutional frameworks have been improved. Montenegro, for a while, has, despite that, been status quo situation, and strategic thinking is needed in the sphere of rule of law, but also political will and competence of individuals in institutions, and individual accountability should also be focused on. So in that sense, there still remains the gap between de jure and de facto rule of law, which means that in practice, many provisions of the rule of law are not implemented, not observed, not monitored, and such situation is an impediment for some imperative issues, and that's observance of law, equal access to justice, and prevention and suppression of corruption. So clearly, essential reforms are needed. Effective reforms, proposal of better legislative solutions, dialogue in the parliament, cooperation with international partners, instead of practice of adjusting work to personal interests and influence of executive on judicial power. Also, new majority should have a consensus, so no rule of law issues in order to achieve solutions, achieve progress, and effectively relaunching the negotiation process. We know that according to the new methodology and according to the new paper, a new non-paper on new methodology excludes the possibility to close a chapter before preliminary or interim or transitional benchmarks, rule of law benchmarks are fulfilled. The key issues are still the political related to political influence of decision making and institutional effectiveness in many areas of the rule of law. So, having in mind the findings and recommendations presented by Mr. Markovic, in the next hour, we'll talk with relevant experts about the topical issues, challenging issues, in order to identify the key weaknesses and strengths of the rule of law system in Montenegro. So this concerns policy options, research activities aimed at strengthening the rule of law in Montenegro. So it's a pleasure to introduce our dear panelists, dear Mr. Miloš Radović, Judge of the Supreme Court, Ms. Valentina Pavlicic, Agent of Montenegro in the European Court of Human Rights, Ms. Vesna Simović-Zvicer, President of the Judicial Council and a Professor at the University of Montenegro, Mr. Stevo Muk, Member of the National Council for Fight Against Corruption, High-Level Corruption, and President of the Steering Committee of the Institute Alternativa, Ms. Jelena Đaletic, State Prosecutor, in charge of cooperation with Eurojust. So let's start. As I said at the beginning, I'll try to ask you each 3 questions. In the first cycle, we'll talk about independence of judiciary. So we're trying to stick to the structure of the report. Mr. Radović, one of the first progress reports for Montenegro European Commission states high level of political influence on judiciary. The assumption was that with the constitution from 2007 that defines the selection of members of the judicial and prosecutorial councils will ensure independence of Montenegrin judiciary. So if we look back at this 15-year period behind us, have we managed to ensure such independence of judiciary? Also, what is your view of these new proposals coming and suggestions coming from the new governing structure? Do you believe that they would actually contribute to ensuring independence? Thank you. You have asked a very interesting question, but before I answer it, allow me to extend my gratitude to SEDEM for this excellent report. The only criticism I would have is that implicitly responsibility for functioning of judiciary is seen and presented, but there's no direct indication of who's responsible for such situation in the report. Let me remind you that in 2013, the Parliament of Montenegro passed constitutional amendments. Under these amendments, these amendments regulate the method of selecting members of the Judicial Council, also the decision-making formats when it comes to selecting Supreme State Prosecutor, President of the Supreme Court, members of the the Prosecutorial and Judicial Councils. And this issue back then, for me, was very interesting. The amendments were passed by means of a compromise. And I already, back then, I had this question in my mind. I was not sure whether that was a compromise based on compromise, because after the amendments were adopted, compromise, which is not based on principles, resulted in selection of members of the two councils. And we have a situation now that the same people who were selected back then are members of the current judicial and prosecutorial councils. I know that the state back then acted out of necessity, to put it that way, when it decided to extend the term of office of the existing members of the Judicial Council, those who belong to the category of renowned legal experts, and I underline renowned legal experts. And the Venice Commission back then supported the state in such action, but I am also sure that this law was unconstitutional because the Constitution regulates the term of office of members of both councils. It says that this term is a 4-year period, and definitely this term of office is unconstitutional. So that's the bottom line. Also, these two councils, they have renowned legal experts, and you identify this in your report, that there are no criteria for the selection of such experts. I am afraid that the councils have legal experts in respect of whom we do not have any, proper professional or expert background info. And I'm afraid that the situation will remain the same even when they leave the council. In other words, political influence is possible. And I agree with your report and Greco that the Minister of Justice should not be a member of the Judicial Council. So let me just clarify that I used to be a Minister of Justice and a member of the Judicial Council, but I was very cautious about the majority opinion of judges in the Judicial Council. I was very cautious about, and I tried to present my views very carefully. So I have reasons to ask myself, and I also ask myself this because of some recent data about retirement of judges. Now we're talking and discussing whether judges should retire at the age of 62 once they meet the early retirement conditions, or women should retire at 64 and men at 66 or 65. And Judicial Council on October 15th presented this very attractive, convenient opinion corresponding to the opinion of judges as regards their retirement age. I now believe that there are judges in the Judicial Councils who would rather agree with the Minister of Justice about when judges should retire than the opinion of judges. And that's why this is my expectation, and I'm actually happy that the President of the Judicial Council is here with us to confirm or deny what I just said. Thank you. Could you briefly just respond to the question about the proposals of the new governing structure? Do you think that these new proposals, if you are aware of those, will ensure independence, as I asked? You mentioned the involvement of the Minister of Justice in the Judicial Council, and we hear, at least as far as I know, for the Prosecutorial Council, there's still this proposal about the representative of the Ministry of Justice. I am not aware of their proposals. I'm not familiar with them, and I haven't read about those in the press. If they want to hear my opinion, I'm willing to discuss those proposals with them, if that is beneficial for the Montenegrin society. Thank you for your answer. Definitely, this topic and these issues deserve a broader consensus. Ms. Pavlicic, most lawyers believe that rule of law cannot be achieved by merely accepting the idea, which will be put in practice by itself. It's necessary to create strong state institutions which will restrict the power of individuals, establish individual accountability in institutions, and human rights, democracy, and general goods will then find their place in the work of public authorities. As a representative of Montenegro in the European Court of Human Rights, and also as someone with years-long experience, legal experience, how is it possible for Montenegro to achieve that goal? Well, the way you started your question, I should probably say that I advocate the same view. And it's not actually a view, it's a European standard. That the rule of law must not exist on its own. Rule of law should be implemented by strong, independent, powerful, and competent institutions. When I refer to this kind of institutions, I mean institutions represented by people who work in them. Today, the public believes firmly that no matter what the decision is of a judicial body, we immediately are critical of such decision without a proper dialogue. If this any given institution failed to implement provision of the law or failed to properly interpret the legislation or failed to ensure compliance with international standards. In other words, we do not have this awareness that dialogue is so required. What is a dialogue? Dialogue is not a conflict between different institutions. Dialogue is about presenting views, presenting powerful arguments. So we have to reach that level, that kind of society in which citizens abide by law, but also those who pass legislation are also abide by law. How can we do it? Only if both sides reach a certain level of development. So that's our prerequisite, to create that kind of environment in the society. My job is to protect state interests in an international court, and I'm very well aware of our legal framework. I have to tell you that we have everything the way it should be. The question is whether we interpret our laws in line with European standards or with the case law of the European Court. Also, without any doubt, when we talk about institutions and this kind of environment that should be created, we must carry out some sort of evaluation of all those who work in those institutions, because today we constantly talk everywhere, and on every occasion we talk about independence. Independence and accountability go hand in hand. If we, as responsible persons, as persons who are doing our jobs, if we do not do our jobs the way that we should, why is there not an accountability process initiated? Because the fact that we fail to act the way that we should, then our reputation will be damaged, what can bring back the reputation? Only people in the institutions. That result cannot be achieved by any law. And actually, we tend to over-regulate certain things, and then we have legal norms which are mutually conflicting, and then we do not know how to implement those. And the third factor, extremely important for effectiveness of judiciary, is whether judicial decisions are enforceable, whether they can be implemented. What does it mean if a court spends years on formulating a legal position and a standard, and then we do not have their judgment implemented in practice? I'm telling you this because very often we have a lot of complaints against, on account of judicial decisions not being enforced. And these cases end up in the court in Strasbourg. So, and why does this happen? What I'm telling you today is what I've presented in my work report. I've gave also in that report certain recommendations, and the government adopted conclusion as to the things that we need to change in practice so that we have less applications in Strasbourg or in other international arbitration bodies. For me, it's very important to have good reputation, for our state to have good reputation. Who needs to preserve that reputation and protect it? These are institutions and individuals both. The executive power, Association of Judges, Judicial Council, Supreme Court, they all must ensure harmonization of case law. And if we see a certain state authority or an individual failing to comply with decisions, then the law on civil servants and state employees comes into play. And performance appraisal is regulated by this law. We, in practice, see that all civil servants get excellent evaluations. Why is that the case? And the European Commission believes that our judiciary is moderately prepared. Let's make it absolutely prepared to apply European standards. The only way for us to do it is if we change the mindset of individuals who work in institutions, and if we also change the way they interpret the law. Thank you. This figure that Mr. Markovic mentioned, number of applications in the European Court of Human Rights compared to percentages valid to other countries, maybe it tells us enough about the effectiveness, understanding, and interpretation of judgments of the European Court of Human Rights. And it's also complementary with the data about public trust in judiciary, which is at a very low level, and that constantly drops down from one survey to another, leading to the situation where people rely on external instances. It is true, yes, Montenegro is actually the first on this list. Of indexes of number of applications per certain number of inhabitants. Of course, it does not mean that all these applications are well-grounded, but actually a good portion of them are. Why are they not well-grounded? Because we in Montenegro are yet to define this standard about what application before an international court actually means, because our citizens always say, I will go to Strasbourg, all the way to Strasbourg. They always think that no matter what judicial decisions are made in Montenegro, they will have to go to Strasbourg. Quite the contrary. Our courts are doing quite well in that respect, but that must be visible. Thank you. Ms. Simovic-Svitzer, the main element of the non-paper about the application of this methodology in accession negotiation for Montenegro published last month is that none of the new chapters will be able to be closed before interim benchmarks, rule of law benchmarks are fulfilled. So it is up to us now. This methodology also strengthens the role of the EU member states in the accession process, and they will have the right to oversee and scrutinize the process, for instance, by involving their experts in the field. Should these changes be worrying our bodies, given the results that we are talking about today, and given the responsibility of holders of judicial functions? Let me first welcome and greet all the panelists and participants, actually those who are with us on the Zoom platform. I would agree with previous speakers when they talked about international standards. Of course, we have to implement those standards if we want to close a chapter. You also mentioned some comparative experience and experts who will potentially be involved in certain activities. When the law on judicial council and judges in 2015 was amended, I said back then that we can't really implement all comparative experiences and practices in Montenegro. Montenegro is not Italy. I will be specific. I will mention the appointment of judges. We can't fully implement this model in Montenegro because it turned out that we had some local issues, local problems. So we have to strike a proper balance between the standards that we must apply and our local circumstances, and that we must use in the dialogue with representatives of other countries, EU member states, so that they understand the context in which these arrangements should be implemented. It's in vain if we have a good, it doesn't matter if we have a good solution if it can't be implemented in practice. I wouldn't agree with the statement that our legal arrangements are perfect. Well, in principle, yes, but in practice, we have terrible problems with certain institutions. Valentina was rightly said that we have to strike this balance between independence and accountability of judiciary. Very often we are criticized in the Judicial Council. They ask us, why do you have so few disciplinary proceedings? I tell them, well, I can't really initiate the disciplinary proceedings. I do not have that power as president of the council. Up until 2015, we had much better legal arrangements. Any member of the Judicial Council was given the chance to initiate such proceedings. The legal provisions currently in force are not good enough. I will remind us all that we have of this very delicate situation last year. A judge was, final decision, judicial decision was made against him on account of him being unworthy of his judicial function. To make things worse, the Judicial Council was informed of that by an NGO, not the president of his court, who was actually required to do that. And now we ask ourselves, well, what was it that we could do back then? I could ask the president of the court why he failed to do it, and we got this very problematic answer that proves that Judicial Council does not enjoy proper respect. And this president of court failed to inform us of such conduct of his judge. According to the law, the proceedings against this president of court can be initiated by his immediate superior, actually against this judge, can be initiated by his immediate superior or president of the Supreme Court. His immediate superior is the president of that court, and he did not think that action was needed. My opinion is that whoever was at the top, and that's the president of the Supreme Court, that person should have initiated proceedings against this judge. So our hands were tied in this specific situation. I do not have any problems with presenting my view because I feel embarrassed. I feel embarrassed for all those honorable judges who are embarrassed by the conduct of this one judge. Valentina rightly said that we have to raise these individual cases because we want to avoid these individual cases simply damaging the reputation of all those other diligent, hardworking, and honorable judges. You mentioned the membership in the Council of renowned legal experts. I will tell you that the current legal arrangement about selection of these members are not good enough. I avoid saying that renowned legal lawyers or legal experts, I don't like that formulation. I believe it's better if somebody else says that I'm a renowned expert, not myself. I think it would be better if this renowned lawyer is recognized by an association, by the University of Montenegro, bar association, any professional association which will propose them to the parliament, and the parliament would then appoint them on the basis of certain criteria. Political activities here mentioned as a criterion. I believe certain limitations should be imposed here. For instance, members of the Council of the Anti-Corruption Agency, well, these members cannot be members if they were politically active in the last 10 years, because, you know, Montenegro is a small country. We can't really restrict them this much. Or you can't really say that we do not have too many people who are interested in these positions or who are fulfilling the requirements and who have not been active in politics. As for other criteria, well, these are regulated by the Constitution, and we in the Judicial Council cannot deal with it. We need 2/3 majority for it. Dialogue, social dialogue is also needed. Certain differences have to be overcome, political differences primarily, and also national interest has to be identified so that all these actors who are in the parliament should sit down together and talk. Maybe constitutional amendments are needed. Different reports say that President of Supreme Court and Minister of Justice should not be members of the Judicial Council, and they are members now, and they are equal to all other members. I can't tell them you should not take part in resolving this or that issue because they are members of the Council just as I am or anyone else. Thank you. Thank you. Now we are at the time when these proposals are made by the new parliamentary majority, and the government also, actually the government has proposals for amending laws on prosecution. Law on courts will also in the future be amended. I haven't really seen these legislative proposals, but I heard last night from Deputy Prime Minister, Mr. Abazovic. He mentioned again a representative of the Ministry of Justice in the Prosecutorial Council. So this is a topic that, well, we could spend additional time on. Mr. Muk, I have a question for you. It's about some general issues and challenges regarding legality and legitimacy of administrative conduct, administrative activities, and judicial review of administrative decisions. It's a bit of a tricky situation. Thank you for your question. Thank you for giving me the chance to take part in the panel to discuss these topical issues. Certainly, it's important for our NGO to present our views. We have taken part in the processes related to activities of judiciary, prosecution as well, especially special prosecution, and we have witnessed many challenges associated with independence of courts and prosecutors' offices, especially the consequence of absence of this independence, professionalism, integrity. Is actually the absence of results of activities entrusted by the state to these institutions, and also absence of results with respect to chapters 23 and 24. And so we are also involved in public administration reform activities, and in that segment it might not be too important for the public administration reform, but it is important for judiciary, the following actually issue, and that's the issue of protection of human rights and protection of individuals and legal entities in administrative disputes and administrative procedures. So we have become quite familiar with the situation regarding administrative disputes and their average length in the administrative court. In 2015, this is very interesting to actually compare how we felt and how we looked at things back then and what actually happened. In 2015 in Montenegro, the average length of an administrative dispute was 6 months. The idea was to implement the strategy for reform of public administration and other strategies. The idea was to reduce this average duration to 4 months, which was not even too ambitious back then. At the end of 2020, average duration of administrative dispute is 17 months. I don't know if people know how important this issue is, and perhaps if we look at it in isolation from other issues, it wouldn't be too important if it were not just one segment in this very tricky situation in which we have this ping-pong effect that involves many challenges faced by citizens or companies if they get involved in an administrative procedure or an administrative dispute. If they want, of course, to exercise their rights before different first instance bodies and then second instance bodies and administrative court. We ourselves were trying to exercise our right to free access to information, and we also filed different applications with the Anti-Corruption Agency, and we can tell you firsthand that citizens are really prevented and companies are prevented from exercising their rights and pursuing their interests. And that's why I wanted us to raise this issue, because this issue, despite being highly relevant, is completely neglected in the judicial reform. I believe that administrative court, actually a portion of their problems is of objective nature, but quite certainly there are some subjective reasons for this shocking data that I just shared with you. This data comes from official statistics. It's not something I invented. This is a fact that should actually make us all worried. And with this long duration of administrative disputes, it doesn't actually guarantee that citizens and legal entities will actually experience a situation of legal certainty, because very often and normally citizens and companies are being sent back and forth due to procedural reasons, due to procedural errors of first instance bodies, and their cases get reopened and reopened. So that's why we're talking about this ping-pong effect. So those who decide to get involved into an administrative dispute, they end up in this vicious circle where justice somehow is absent. And very often life goes at a much faster pace than the pace of courts. It happens that we get a piece of information 2 or 3 years later, and the relevant court proceedings are still lasting and are not completed. So the role of the Constitutional Court here is very important. Unfortunately, I have to say that they lost their credibility exclusively due to their own activities. We've talked about those reasons on several occasions already. Administrative Court and Constitutional Court, as I said at the beginning, both these courts, well, we have to do something about them. We have to, as a society, we have to deal with them much more to bring back these two institutions to back to their integrity and efficiency, because without integrity and efficiency, I don't think actually, I believe that the rule of law will suffer if we do not achieve that, and the exercise of human rights. And ultimately, this has to lead to what we already mentioned. That's the lower level of trust, public trust. Those who are directly involved in these cases, these procedures, and those who learn and are informed of such procedures, such cases indirectly. So I believe that this issue will get the attention it deserves in the future. This is also an issue that should be addressed by the Public Administration Reform Strategy and Judicial Council and the management of these courts and the Parliament, I believe, because the Parliament should have to take part in resolving these issues, because this situation has been going on for too long and the consequences in our mind are really devastating. Thank you for your answer. Yes, this is a fact. This issue has not received sufficient attention and the attention it deserves. You mentioned human rights, and we must not forget the right to a trial within reasonable time. And we talked to Ms. Pavlicic about it on other occasions. I do not want to make this conversation too pessimistic, but let me just tell you about our latest discrimination survey in Montenegro. We asked citizens, we asked them to tell us whether they would know what kind of rights they enjoy and how they are able to protect them. Only 20% of citizens, actually, according to this data, know and are aware of their rights. But what would happen if all of our citizens are aware of those rights and start using those the options they have? In that case, judicial institutions would be faced with a huge workload, and that means that efficiency is something we must work on. Ms. Jaletic, The new parliamentary majority suggested new legal arrangements, which provoked different actions of different social actors. Also, European Union officials and the Venice Commission reacted, and these arrangements, these proposals are revised. The new proposals were now presented. So what is your view, these proposals regarding the composition of the prosecutorial council, and is that a step forward or backward when independence of judiciary is concerned?
New parliamentary majority proposed new legal solution in terms in relation to prosecution, which caused different reactions. And after the consultations with the EU and Venice Commission, they were revised, and revised proposals were forwarded to the Venice Commission. What do you think about the new composition of the Prosecutorial Council? What do you think? Is it a way forward or backwards when it comes to reform of judiciary? Thank you for your question. Let me thank the organizers for the invitation to come to this panel, to take part in it, to salute panelists and our colleagues who have been with us through Zoom application. Amendment and the change of organizational legislation that regulate the work of the Prosecutorial Service and Special Prosecutor's Office has been a topical issue for Montenegrin public for months. And then that was proposed by the new parliamentary majority. They proposed amendments and they proposed a new law, and the extended session of the Prosecutorial Service, Association of Prosecutors, have already reacted to that. We published our reactions to new legislation, to the proposed legislation, and to all entities in this process. Venice Commission gave its opinion in March regarding the new legal solution, the proposed solutions, and in the Ministry of Justice and Human Rights have already organized consultational sessions. To that, the law on prosecutorial service has regulated the composition of prosecutorial council, and majority of the council as proposed, as prescribed by this law, comes from the ranks of prosecutors, and this is made according to the European standards. And the model made ensures that prosecutors, we believe, justifiably so, make majority in this council, and the council performs all the duties and activities as prescribed by law and by constitution. The new solutions, the proposed solutions, as we saw, have envisaged that distinguished lawyers and representatives of Ministry of Justice make majority. Venice Commission gave its opinion, and they suggested that we should then envisage qualified majority for the appointment of those distinguished lawyers members. There are some recommendations in that opinion as to how those lawyers should be elected in order to avoid politicization of the Prosecutorial Council. We had a conference of prosecutors. We have released a press release. We communicated it through the media. So with the new proposal, the new draft proposal has been sent to the European Commission, and it was not communicated to us. As we learned about that through media, we didn't have time to read it and to get acquainted with what's inside. We hope that we will have opportunity to get acquainted with the text of this new version, and that we will have public consultations through which the prosecutorial service and prosecutorial council, prosecutors generally will have will be able to give opinion about that. At the public consultations, the public, the NGOs, and everyone interested would have the opportunity to speak their minds, to give the comments, and then they should be consolidated together with the opinion of the prosecutors about that, and hopefully we could come up with the most convenient, the best solution about that. Our joint goal should be the best solutions, sustainable, and I underscore sustainable solutions. My recommendation and recommendation of the prosecutorial service and prosecutorial council, as seen in this press release, should be that with the help of international experts, we should endeavor to make the best legal solutions so as to enable more efficient prosecutorial service and better track record eventually. My intervention was to indicate to you how we learned about the proposed acts, and there is a cause and effect relation effect of this to Chapter 23 for our negotiations. If we want to meet benchmarks, we necessarily need to enable cooperation among all involved stakeholders, and this is the only path to follow. This is not upon the individuals or individual institutions. This is the path that Montenegro should take. We have to cooperate in practice, and to show that we are a good partner to the European Union if we want to join European Union, both formally and essentially. This is the essence of what the report of the European Commission indicated to. And this is what the European Commission insists upon. It goes without saying that the branches and division of powers should never be seen as the lack of communication, as the separate communications. Each branch of power should cooperate with the other, but they should act independently, independent from each other. Let's wait and see how it goes in those processes. I regret to hear that for the second time today that relevant institutions learned about what's going on in relation to them through media and not directly. I wanted to say something following up to this remark. When it comes to the interim situation in Judiciary, in the prosecutorial service, we have acting positions in this regard, acting chief state prosecutor, acting president of the court, and etc. How should this be addressed? Or whether clause of balance will be activated or not, I will leave it up to the politician. But in answer to the first question, I see this coming from 2013. I addressed the responsibility for this on former opposition and former incumbency and former opposition, and the present incumbency and present opposition. We don't know how to break up from or break away from this interim status. I don't know what it looks like in relation to prosecutors, but I have checked the situation here, and it says that acting chief state prosecutor, they envisaged there could be someone who is not a prosecutor, him or herself. If it is so, and I'm not sure because I didn't have an opportunity to look into the new text, media reported about that only. Then the political then decision, as I assume, is that they need to introduce a tutorship of a sort on the prosecutorial service. If it is so, then they believe that we should remain in this situation where we only have acting heads of judicial institutions. So what we need to do is to protect independence of the judiciary. Every president of the court has to come before. We have to confront everyone and say that we have to remain independent. And my message is, please preserve and keep and protect the independence of judiciary. We should not aim to create people who obey, who are obedient, because it can backfire even very strongly. Thank you for a concise answer. We come back to what we started with: individual responsibility. It can't be prescribed. It can't be regulated to the full. It is. As Mr. Marcotte said, we need to have that mindset. When we talk to Ms. Pavlicic, the level of knowledge that is presumption for integrity, that is precondition to integrity, should be in place. Let's see what are the messages we get from the European Court for Human Rights. We mention that very often when we talk about essential improvement of the criminal procedure, especially in relation to Articles 2 and 3, respectively, of the Convention, European Convention on Human Rights. What are the messages we get? First of all, let me tell you one information. A couple of days ago at the seminar that we had at Judicial Training Center, our academy, Judicial Academy, when we spoke about this, I learned one information, and that is that for 15 years that we've been educating people through this institution, and I was in a way amazed. It's been 15 years that we've had training and that we've been talking about standards, and when I come into observations and preparations to represent our state before the court, I can see it and find it and trace it in just couple of decisions and rulings of the courts. So we have to take into consideration not only formal education and training in order to have someone a good candidate for judge. We should not invent the wheel. There are instructions, there are standards to be met. How to select judges, for example, for judges in the European Court for Human Rights, we should follow into their footsteps. As Ms. Witzer said, how to establish whether someone has the expertise, commands the knowledge. What if someone got the top marks and didn't do much in practice, either in science or practice of the law? So what is the message? I come down to this. When it comes to absolute rights, right to life and prohibition of torture and ill treatment, inhuman and degrading treatment, so we have one of the shortest articles in the convention, but we have already been known to the European Court for this. I'm not sure that in last couple of years we have understood this article. Let me not mention some of the cases that were closed lately, where we, in a case, won over the applicant's arguments. Then we need to be aware of what we have done in our institutions when it comes to infringements related to Article 3. There we have the situation where in Strasbourg, in the first judgment in relation to our country, sent to us a clear message. However, we didn't accept it. However, we didn't essentially and meaningfully applied it. Defending the state in Martinovic versus Montenegro, Baranin and Vukcevic versus Montenegro, no matter what we thought, we citizens thought about the court of this or that regard, we do have our constitutional court. Do we need to reform constitutional court then? The constitutional court is not the institution that we necessarily have. We have the Supreme Court, but if we have it, we have to respect its work. When we got the messages and when the Constitutional Court found that in those cases prosecution didn't carry out meaningful and full investigation, and that infringements were made in terms of procedure and substance, only then, instead of enforcing and implementing the judgments of the rulings of the Constitutional Court, instead of just implementing and enforcing what the Constitutional said, what we got is the conflict between our institutions. I'm not defensive about the prosecutorial service. I'm not defensive of the police directorate, the state. I'm defending the state. When the Constitutional Court found infringement, the period from when it found it and when this was enforced, I was asked in Strasbourg, and I had to report about that, what prosecutors did after that and what police directorate did after that. I was ashamed. Why? Because I saw that prosecutorial service only acted in formal way. We have a general act of a sentence and a half, where a competent prosecutor requested from police to get information, and police answered to the request, we will inform you in the statutory deadline, within the statutory deadline. And we have a couple of documents like this, which essentially and content-wise are absolutely the same, because I start from myself. If I'm a prosecutor, if I were a prosecutor in charge of investigation, and if I saw that a certain institution doesn't do as I say, then I would have to do something, because I have to do the activities, to perform the activities within the statutory deadline. So what happens if if a citizen wants to then apply to the European Court, and then I inflict damage, then this is damaging for my state. And we could end up in a serious situation, in a systemic infringement. Why? Because the case the Sinishtai that in 2015 was ruled, we have not finished the investigation yet. This was not the closed investigation, and there is no there is no instruction by chief state prosecutor given to prosecutors what they should do. So after such a long time, we don't know who on the way from the police to the higher court in the police car, in the police van, with two policemen in charge, with a driver, who inflicted damage, who harmed and injured that person. So if we cannot say, we have to do something before it comes into the statutory expiry of a statutory period. We need to act in a serious manner, in a responsible manner, and send that message to the European Court of Human Rights. As for Martinovic, this was procedural issue. There was a plea bargain, and we paid damages 130,000 euros damages from the budget, but we haven't closed that case to the full. We don't have a closed case. In this regard, I read the decisions, the repealing decisions of the competent court, and we cannot say who used the public, and who inflicted the damage of this victim on the hand or elsewhere. This is to say that we don't understand the status of a victim according to the standards. Let me ask you, have we then, in this, if the situation is such, when we hear such clear and strong messages and when we have judgments of the court in Strasbourg, did we see any session of the prosecutors? Was there any extended session of prosecutorial service to address the case? Have they convened? Have they come together? Have they say, oh, this is terrible, let's see what we could do. Let's see who's responsible, who's to blame for this in the prosecutorial service. This is what we missed in prosecutorial service, in judiciary, because in essence, and I would love if to be wrong about that, because there is a seal of silence. There is a deal of silence, like in judiciary and everywhere, because they don't want to name names, not to protect them, but to preempt any control, any individual responsibility to be assumed. This is how it operates. So prosecutors and judges spoke about this and said that if they have ever talked about that openly, we wouldn't have ended up here. The society, the community lives in these institutions like the status quo, and despite all challenges and problems and issues that have been with us for quite a long time, they are not as of yesterday. And that is what, as an epilogue, had this proposal of the parliamentary majority. The proposal was not good. The first one, maybe this one is better, but I haven't seen an intervention by the Association of Judges or prosecutorial session or prosecutorial service in general. This is what we need, internal reactions from within. This is what was missing. Had it not been the case, we wouldn't have been in the position to say. We would have seen some dynamics, we would have seen some initiative, and then we would discuss it, and we should examine it. So in this case, as it was not the case, it is just to close the ranks, to defend ourselves. We want to defend ourselves from the reform of the prosecutorial service or judiciary. And I believe that Mr. Radovic has come late because he tries to defend independence of judiciary, but he came late. We are defending it from some politicians, but not from all. And I've been very careful and attentive listener, and I see that from the prosecutorial service, not only today, but also before, they are defending themselves against some part of political spectrum, not from the whole, from the entire spectrum. So I'm not in favor of hands-off from independent judiciary. I don't think that this voice, this articulation has not been heard before. Had it not been the case, we would have ended up in a somewhat different situation. When we speak about independence, political influence, there is no much of a political influence because why? Because there is no need for that. Because in the system where most of judges and prosecutors have been appointed either in the system of communist system or during the rule of 3-decade-long rule of the ruling party. They have all kinds of networks, family networks, relatives, and so on and so forth. This is a problem that is very hard to address and solve. So this is a system with self-reproducing capacity, and with such a capacity and with such a system in place. Sorry, I will finish soon. So this system actually led to arrested state, and this is what the Commission indicated too. So this is why we decided to do something, to act on that. Mr. Radovic, I will give you the floor. Since we have come to a part where we need to do the third round of questions, I prepared them. But when there is spontaneous discussion, it's always very good. And I would like to ask Mr. Radovic to take the floor, and then Ms. Jaletic. Only. Mr. Mook, I haven't come late. Only those who decide about this have come late. So I don't like your sentence that I address it to former incumbency and former opposition, and present incumbency and present opposition alike. So I have to tell you something from my personal biography. In 2010, I was appointed as a judge of Constitutional Court. Regarding the amendments 2013, they have asked for general restructuring of the Constitutional Court, and then I said no, because this is what I assumed was an attack on the constitutional and judicial system in Montenegro, and everything I said about the consequence only followed so everything that happened was the consequence of that. There were no those who are more or less responsible. Everyone is responsible for that. So this is how they appointed them, the councils, both judicial and prosecutorial. And in that the consensus, and against the backdrop of that consensus, they managed to appoint both councils. Why can't they do it now? So don't blame it on me. I regret that in this report they didn't specify who is responsible for this. It is implicit in this, but they weren't explicit about that.
Thank you. Ms. Jaletic, please be brief. I'll be brief. I'll touch upon this. These specific legislative proposals given by Association of Prosecutors, Prosecutorial Council, and I mentioned that the council was formed by the Ministry of Human and Minority Rights. And of course, this body can consider, can discuss all comments or proposals to improve potentially the legal arrangements. I will remind you the European Commission insisted on full implementation of provisions from the 2015 about the State Prosecutor's Office and Special Prosecutor's Office. So now that we ended up in a situation where we have new ideas, new legislative amendments and suggestions, of course, this will be all considered. I will remind you that in the past, when working groups, it's a practice, working groups are formed to draft legislation. They are formed by the Ministry of Justice, and we have representatives of courts, prosecutors' offices, NGOs, and these working groups come up with certain legal arrangements. And of course, the agent mentioned the instruction adopted and issued by the Supreme State Prosecutor about cases when Article 3 was violated, and the instruction refers to and calls for urgent and timely investigation of suspicions of torture and ill treatment committed by police officers, prison officers, and of course that instruction is in place. However, I don't agree that in the cases in which ineffective investigations are identified, we immediately start thinking about responsibility for this, disciplinary responsibility of prosecutors who were in charge. I would rather opt for our action towards making investigations more effective, but that does not depend only on prosecutors. That depends also on other bodies, other authorities, police administration primarily, and police officers who are detecting perpetrators. These issues are too complex, I know, and of course, yes, responsibility for these cases, yes, but the law clearly defines disciplinary offenses and what they mean. We can't be held accountable for anything else but disciplinary offenses clearly defined by the law. There are persons who are authorized to initiate proposals for determining disciplinary liability. Very often the public asks about these cases and why a prosecutor was not sanctioned for something, but let me just remind us all once again that state prosecutors can only be held accountable for disciplinary offenses clearly defined by the law. Each disciplinary offense has to be clearly defined. It must not have the elements that exist in these new proposals. Thank you. I'm also apologizing for using your time. The issue of independence of judiciary is extremely complex, and there must be more than one angle to look at it. We have external, internal, functional, individual independence here. I agree with Mr. Mook that independence of a court, independence of a prosecutor's office is not exclusively the right of judiciary, courts and prosecutors. This is the right of citizens. I agree with Mr. Radovic that no court, no president of a court may allow external influence, but this internal influence should also be avoided by the presidents of courts, by presidents of and managers of prosecutors' offices, and independence of judges and prosecutors should be primarily identified as the right of citizens rather than the right of judges and prosecutors. This is the aspect that we tend to neglect very often, to overlook it somehow. And this, now that we are discussing these organizational laws, we are still taking this other approach, the approach that entails us thinking about external independence, actually independence from external influence. I'm just placing emphasis on this, that it is the right of citizens to have judges who are independent. And the system of accountability, the system of performance appraisal, this is the system that should ensure that in case of violation of the rights of citizens, these systems are put into operation and certain measures are taken. Thank you. We are already behind the agenda, so I will briefly sum up some remaining questions, and maybe you could, if you could give me some short and concise answers. Mr. Mook, we already touched upon this third area covered by the analysis, corruption. Can we expect any better ratings by the European Commission, given that the National Council for Fight Against High-Level Corruption that you are a member of now has also members of the civil sector? Can it give us optimism? Can we be optimistic about it, about our improvement? We haven't touched upon the role of control mechanisms, parliament or independent bodies. So are you optimistic? Is this a step forward? Are you asking me about the new report of the European Commission? Well, if you are, their assessment of the situation will continue to be based on the results of this special prosecutor's office and this police administration. I do not think that police administration, after these personnel changes, I don't think that they've had enough time to demonstrate, to show a drastic difference compared to the previous police. And of course, the appraisal of their results is what the final assessment of the European Commission depends on. And as for the council that you mentioned, Anti-Corruption Council, well, this is an advisory body and we are enthusiastic and we want to give our contribution. But after all, we're only an advisory body comprising experts who will be certainly collecting data about certain cases that may have the potential, to put it that way, of being cases of corruption. But on the other hand, we will also try to give advice to the government on how to improve policies and regulations which may contribute to preventing corruption. And that is also an important segment. The Council I see that they criticize us, that we intend to take over authority from state institutions. We do not intend to do that, certainly. And of course, the police and prosecutors, they should not wait for our actions. They should take actions themselves on their own. They should show us that they are ready to implement activities and show results. Of course, this is going to be, we'll see what their results will be and what the council, what kind of results they achieve. Of course, we'll see. This will be affected also by the contribution of other stakeholders and the government and the parliament. Their efficiency is also what final results, their efficiency in responding to our initiatives is what final results depend on. So, if in these specific concrete cases, if there is a potential for criminal actions by police and prosecutors, criminal, yes, prosecution, well, that depends on what they find in these cases.
Yes, it's clear to me. I was just thinking if this control function, generally speaking, the parliament's involvement in this is leading to a new quality. So we don't see we want to have the control function institutions on board for that. I want us to wind up the discussion, so I give up the last round. I would like to allow the speaker to join. I have to tell you my opinion. It is good to hear criticisms, to take them on board, whether it comes from NGOs or from elsewhere. I want to carefully listen to that. As for the acting state, for the interim or interregnum state, I agree with Mr. Mok. We have to have our initiative. I can't motion for the new law, but I could indicate for the need to have one. We haven't managed to elect the president of the Supreme Court. He didn't win majority of votes there. We reconvened today and discussed the issue, but now the legislative solutions are such that, and I indicated to that from my position of president of the Judicial Council. So we convened today and discussed the issue, and we will come up with a joint proposal of the Judicial Council that we will present to the Ministry of Justice, and then they might forward it to the Parliament. We will address in this initiative the election of the President of the Supreme Court, and we had two candidates, and we didn't have opportunity to interview only one. How can I, as I have never been a judge, how can I say that someone is bad for the position, and how can I say anything if I couldn't analyze his competence or her competence against some other candidate? So I believe that we should have at least 2 or up to 3 candidates to select from, so that I can compare candidates as a member of the council, and so that I could make up my mind based on that. So we should not sit idle and wait for someone else to solve our problems, but to do something instead. So from what you said, I see the path out of this deadlock or deadlock broken. Let me check with the other participants how many people are with us. Marco, since we don't have any questions from the audience, Valentina, you have the floor. I want to send a message primarily to state authorities of Montenegro that they should observe standards of the court Morris versus France decision that you have to hand out to deliver justice, and it has to be done efficiently. If we don't have it, we can't speak of normative reforms and normative initiatives. It's very important that we have internally independent institutions, internally independent justice system and judiciary, that our judges hand down the decisions regardless of what his president of the court or her president of the court thinks. If we don't have internal independence, then it is idle talk to discuss whether Minister of Justice should be member of the Judicial or Prosecutorial Council. I believe that there are some other influences and they are much harder. This is what's going on within the councils and within the system, within respective councils. The president of Judicial Council said something about those initiatives. You, from the councils, should vote for the program of the candidate for the position. And this program should be given to the public for the scrutiny like they do in other countries, so that we get an idea, get a hint of what is who's gonna be in charge of prosecutorial service or judiciary. We want to know, because we are lagging behind. You have seen the latest report about the work of the specialized department of the court, higher court, or of the special prosecutor's office. Unless we don't have this in place, we can say that the justice is slow and slow as it is. You spoke about statutory term, and there are lots of cases that ended like that. I'm sorry that we end on this note. I want to thank to all of you for participation. It's good that we had spontaneous discussion, that I didn't have to moderate it, that I didn't need to interrupt or to ask some additional questions. They just were generated. I would give the floor to Mr. Hadenrank to give us some final remarks.
And it's been an interesting discussion to follow and to participate. I mean, we've touched upon wider aspects. Dr. Marcotte spoke about concepts and had this little taux d'horizon, rule of law concept versus Rechtsstaat, the German term, the broader état de droit from France, and as compared to the possibly narrower concept of Верховенство закона, the Russian term that he brought into the discussion. I can only thank again both Mr. Markovic and Ms. Rajcevic for their in-depth result, the booklet and the findings that will be circulated and that you can also find online now. From what he said, I mean, I shall not repeat everything, but I thought it's key that he mentioned that in Montenegro, education activities in relation to the ECHR norms shall continue. And this is certainly something that we at Konrad Adenauer Stiftung also do look into, have been doing in other countries. So this is something where I see potential for future projects from our side as well. I was surprised again about the low confidence rate in the justice system, which is something that has been part of a project by CEDEM. 40% certainly is not very promising. Yeah, there's room for improvement in that. Judge Radovic has mentioned the relevance of the membership in the Judicial Council, and clearly this is being discussed in your country and other countries as well. Which role shall the minister have in that body? Ms. Pavlicic, from what you said, I took out the discussed issue of accountability. Indeed, that's a key aspect, and that is why we at CAS wanted also discuss that publicly from the findings. Ms. Simovic-Zvicar, you spoke about many things, also about the local level and the balance between standards and then taking into consideration the circumstances. But you also openly mentioned that there is sort of a lack of respect to the Judicial Council at the moment. And Mr. Mook spoke about lack of performance in some areas in relation to chapter 23 and 24. Of course, these are key, but he also mentioned some positive aspects, such as the shortening duration of administrative disputes. If I understood correctly, down from 24 to 17 months, so there's promising signs. Ms. Jelitic has highlighted the importance of public discussion of the new draft law now, and I can only reiterate that this is really key. Yeah, if we are talking about transparency in the legislative process, then it has to be inclusive, it has to be very public from the beginning, and to include all public stakeholders. So thank you very much for the lively discussion, and let me end by regretting that I could not be with you in Podgorica today. So from my side, ponovo hvala svima na dobroj I profesionalnoj diskusiji. Nadam se da ćete uskoro ponovo sudjelovati u nekoj od diskusija I organizaciji Konrad Adenauer fondacije. Program vladavine prava za jugoistočnu Europu naše fondacije planira još događaja ove godine u Crnoj Gori, a o tome ćemo vas pravovremeno obavijestiti na našoj web stranici, na Facebooku, LinkedInu I putem naših partnera. Želim vam ugodan dan I ugodan vikend svima. Hvala.
Gospodine Rank, zapravo
Thank you, Rank. Thank you too. Thank you all. Thanks to participants, and let's hope we see you soon, and let's continue discussion on this topic. Thank you once again.